Hi, welcome to Constituting America. I'm Janine Turner, founder and co-chair of Constituting America. And my co-chair, Kathy Gillespie, and I welcome you. Welcome you to our third annual 90 and 90 Day Forum. History holds the key to the future, because that's what we believe. Yes, our founding principles are imperative to know. Knowledge is power. And it's one thing to wave the Constitution around, it's really another to know what's in it. So welcome, and I'm so glad you're going to join us. Please spread the word about these videos and about these fabulous essays from guest scholars from all across the country. And blog with us, spread the word. You can read it, you can watch it, you can blog about it, you can have a what do you have? You can have a, what do you call it? Patriot Club. Yeah, you can have a Patriot Club and play these things and read these things and study, because it really is vital, and we're happy that you're here with us today. Now, just so you know a little bit about this website here, this is our third annual forum. So the first year we had our 90 and 90 Day study on the Federalist Papers, and that's all here, archived on the site. The second year, we spent 90 days breaking down the United States Constitution into 90 small segments, so that is archived here as well. Now this year we decided to break out the amendments and really study the amendments, and I have found this to be an absolutely fascinating process, because I read them with you every day on camera. So we're going to break down in 90 small segments the amendments, and today we are on Amendment 6. Now I do want to mention, give a little shout out about our We the People 917 contest for kids. It's kindergarten through law school. Fabulous opportunities. It's for the kids, the elementary kids, it's best poem, best artwork. Middle school's best song, best essay, best song and best essay. High school, it's best essay, best song, best short film, and best public service announcement. And it's the same thing for college and law school, except we added best speech for a future potential, congressman or woman. So $2,000 scholarships for college kids, $1,000 scholarship for high school kids. All the kids get prizes. Everyone gets a trip to Philadelphia. They get to star in a documentary. If you wrote a song, we do a music video for you. Some kids get to be on Huckabee and sing with the Little Rockers. So it's really a wonderful opportunity nationwide. And we encourage everyone to spread the word about that as well, and send in your entries by July 4th. Okay, so here we go. It's March 27th, 2012, essay number 27, Amendment 6, Right to be informed of the charge. Guest essayist, Professor George Nippereth, Professor of Law at Southwestern Law School. Amendment 6, here we go. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Here we go. The Due Process Clause of the Fifth Amendment embodies the principle that those vested with the power to govern must not act arbitrarily towards the citizenry. This principle has been a long established and deeply held value in Western civilization, dating back to Stoic and perhaps Judeo-Christian conceptions of individual dignity. It was incorporated into the canon law of the medieval Catholic Church on the argument that before banishing Adam and Eve from the Garden of Eden, God gave them a hearing. Cool. Okay. In Anglo-American constitutional history, it found expression in the provision of the Magna Carta, extracted from King John by the nobles, that no free man shall be taken or imprisoned or depossessed or outlawed or banished or in any way destroyed, nor will we go upon him nor send upon him except by the legal judgment of his peers or by the law of the land. Closer in time to the Constitution, that protection was included in substantially similar language in the paradigmatic Massachusetts Constitution of 1780. It is self-evident that among the most fundamental protections against governmental caprice is the requirement that before one is tried and subject to losing life, liberty, or property, one must be notified of the reasons by grand jury indictment or criminal information. Languishing in jail or living under a cloud of unspecified suspicion, with the overbearing power of the state poised to strike at his life, liberty, or property, for a reason not made known exacts all emotional toll and prevents the targeted individual from preparing his defense. In the more modern context provided by the movie Animal House, operating under double secret probation puts the recipient at the whim of a vindictive governing bureaucracy. Then why did the framers not simply limit themselves to a due process protection, but provide various more precise protections for the accused? Individual clauses in the Fifth, the protection against compelled self-incrimination, Sixth and Eighth Amendments, no excessive bail. Amendments are specifications of the broader contours of the due process guarantee in the Fifth Amendment. Many of these specifications arose out of the particular experiences of the Americans with British rule. The specific requirement of notification of criminal charges began to appear frequently in early state constitutions, but unlike other specific protections such as jury trials, had been rare in earlier colonial charters and declarations of privileges and liberties. The Massachusetts Constitution of 1780 again provides a model. No subject shall be held to answer for any crime or offense until the same is plainly, substantially, and formally described to him. Thus, an indictment must not only be clear, but must contain the elements of the offense intended to be charged and sufficiently apprise the defendant of what he must be prepared to meet, as the Supreme Court has opined. The requirement of notice of charges applies not only to procedural steps that must be taken in regard to the accused. There is also a substantive component that the law under which he is charged be written in a way that furnishes him a reasonably definite standard of guilt. Again, this ties into a more general due process notions that a law is unconstitutionally vague if the average person is left to guess at its meaning, or if, based on common understanding and practices, the language of the law reasonably could be construed in several ways, one of which would make the conduct legal. The old saw that ignorance of the law is no defense loses all force if the language of the law is unduly vague. One historical example of the dangerous malleability of law, especially in the hands of crafty and overbearing prosecutors, was the application of English treason law. Before the statute of treason was adopted in 1352, it included various crimes other than warring against the king or aiding his enemies. The contours changed as the king saw fit and extended to ordinary crimes against the peace of the realm, such as the murder of the king's messengers and armed robbery. Even after the statute, it included counterfeiting and listed such oddities as imagining the death of the king, his consort, imagining the death of the king, his consort, or his eldest son, violating his consort or eldest unmarried daughter, or the wife of his eldest son. Even before the text discussed levying war against the king, this statute itself was frequently altered and applied in unpredictable ways until a series of reforms by, curiously, the 17th century Court of Star Chamber and later parliaments. Due to this history, as well as the harsh, even brutal consequences that could result from conviction for treason, colonial charters and state constitutions sought to tighten the definition and rein in the consequences. The framers of the Constitution followed suit and made treason the only clearly defined crime in the Constitution. Interesting. More recently, the Supreme Court has addressed the notice issue in striking down vagrancy laws and laws based on certain personal characteristics. For example, an ordinance from Jacksonville, Florida, was declared unconstitutional that punished, among others, persons who used juggling or unlawful games or plays, persons wandering or strolling around from place to place without any lawful purpose or object, habitual loafers, persons neglecting all lawful business and habitually spending their time by frequenting houses of ill fame, gaming houses, or places where alcoholic beverages are sold or served, persons able to work but habitually living upon the earnings of their wives or minor children as vagrants. To the court, this law cast too wide a net and left too much unpredictable discretion to the police to provide a suitable and constitutional rule of law. Punishing, defined, aggressive begging is one thing. Punishing people hanging out is another. In similar vein, a New Jersey statute that penalized gangsters was struck down because it did not provide a usable definition. More recent anti-gang statute and injunctions have survived constitutional scrutiny because they prohibit defined gang activities rather than a mere status of a gangster. Led by California's Street Terrorism Enforcement and Prevention Act and the state's pioneering use of anti-gang injunctions, a majority of states have enacted this type of legislation. The federal government also targets gangs through the Racketeer Influence and Corrupt Organizations Act, RICO, which punishes gangster forced conduct. The latter example also shows the danger of broadly worded laws, as the statute for a couple of decades was used against targets such as financial institutions and other businesses, well beyond the intent of the statute's drafters. One critic claimed that the only groups not targeted under the law were actual racketeers. The courts recognize, however, that statutes are inherently vague. Language has limits. Indeed, requiring too much definition would likely make a statute more ambiguous by increasing its complexity and verbosity. Don't know. Moreover, statutes look forward and are intended to address actions still undone by persons still unknown. There has to be play in the joints. Conspiracy laws and statutes that prohibit mail and wire fraud, unreasonable restraints of trade or conduct that the reasonable person knows would annoy another by creating the unreasonable noise. Provide sufficiently precise notice. Insufficiency of notice of the charges based on the purported vagueness of a law is almost invariably a futile argument. A defender whose only hope for avoiding conviction is based on such a tactic is well advised to seek a plea bargain. There you have it. George Nipreth, you go. Professor George W. Nipreth. He's an expert on constitutional law and has been interviewed by print and broadcast media on a number of related topics, ranging from recent U.S. Supreme Court decisions to presidential succession. He's written opinion pieces and articles on business and securities law, as well as constitutional issues, and has focused his more recent research on the effect of judicial review on the evolution of constitutional law. Very interesting. He has also spoken on business law and contemporary constitutional issues before professional and community forums. Read more about Professor Nipreth at tokenconservative.com, www.tokenconservative.com. There, we did it. All right. Yay. Please blog with us and spread the word, and we'll see you again tomorrow.